Hello, I am Elda Lebenamar and I hired Mr. Davis on October 2014. My granddaughter was removed from my home and I was told that as a grandparent I had no rights and that my granddaughter will soon be put on the list for adoption. She was put into foster care and I heard of Mr. Davis. I researched and I hired him. The judge told Mr. Davis not once but twice to sit down while we were on the process of trying to talk to the judge. Mr. Davis did not take no for an answer.
Good morning. This is Attorney Vince Davis, and I'm joined this morning by my guest host, Miss Chi. How are you, Miss Chi?
I'm good. How are you?
Good. Anything you we're going to talk about reunification services today. Anything you want to tell us before we start?
Yeah, I actually want to focus on the reunification part, but I wanted to also add that for the last couple of years, I've been getting a lot of calls from parents who are going through unification, right? And then after that, the social worker tells them, oh no, they need to take more classes, or they come up with new allegations, for example. And the reunification services really doesn't go through or doesn't even take place. Oftentimes, also, they send the children to the parents for a few months and then they come back and take the children. So, I mean, there's a lot when it involves reunifications, but I just wanted to bring that up to your attention to let you know what has transpired for the last 2 years. Um, and also, just to let you know that they did a study, and 80% of the children never get reunified with their parents. There's a study that's been done um, to show the corruption of DCFS. So the other 20% unified, 80% of the children are not reunified with the parents.
Okay, well, this is a very hot topic. And let's call this how to flip a CPS case that's going against you and win your children back.
Hmm.
If the judge has ruled against you, if your rights were limited, child is placed in foster care, I'm here to tell you it is not over. The next 30 minutes or so, I'm going to show you how to flip the script, use legal tools the system won't tell you about, and make them reconsider everything about giving you your children back.
Yep.
If you're in a case right now and the odds are stacked against you, I want you to call my office today. Let's fight this back together. And by the way, Miss G, you've asked me on several occasions about free consultations, and I
Yes,
have a. Go ahead.
I want to offer everyone free consultations. I know that on your website they have pricing if you book it online, and of course if you want to book it in person, there's a different types of um, fees for that as well. It increases if it's in person. So I'm asking if we can offer everyone free consultation going forward.
Yes, we
And
can.
yeah, and I would like to book that free consultation. If they can contact me, they can go through me, and I'll book the consultation with you. Okay, and we can have a three-way call with the parents
Okay.
regarding.
Well, I'm going to tell you this right now. I'm only going to give free consultations if the person calls the office and goes through you, because generally I charge for consultations.
Mhm.
So I know a lot of attorneys give free consultations. I used to give a lot of free consultations, but I changed maybe in the past year or so. But you've asked me about giving free consultations again, and I'm willing to do it. Only if they book it through you. You have to set it. They have to call the office. They have to talk to you, and you have to set it up through your schedule and through my schedule. Okay?
Got it. Yep. Thank you.
All right, so let's talk about the reunification services. What is the reunification process? Reunification is the legal and social services process designed to help you regain custody of your child after the child has been removed by CPS. The court orders a case plan at the end of the disposition hearing that must be completed to demonstrate that you can safely parent the child. And by the way, this demonstration has to be to the judge. So when you're doing these reunification services, make sure you're doing it so that you know one day you'll be sitting on the witness stand explaining this to the judge and what you've done.
Right.
The reunification process can take up to 6 months, 12 months, and sometimes in unusual cases, 18 months, depending on the age of the children and the stage of the case. The goal: show progress to the judge, not perfection, but it must be documented. Part 2, what is a case plan? The common components of the case plan are parenting classes, drug and alcohol testing, drug and alcohol rehabilitation courses and counseling, domestic violence counseling or anger management counseling, individual therapy or mental health treatment, housing and employment stability. Often the reunification case plan includes supervised visitation. Hey, Ms. G, I'm getting some feedback on you. If you're not going to speak, mute yourself for me, see if that's better. One of the tips: start services before the court tells you, and judges notice this initiative. Starting reunification services does not mean an admission of any guilt. In my humble opinion, starting reunification services, whether you feel you're right, wrong, guilty, or not guilty, will only help you. Okay, and it's not an admission. Part 3, weekly reunification habits. You need to attend all court-ordered services. Go to every visit. You want to go early, you want to be prepared, focus on bonding with the child or the children. You want to collect documentation from service providers, your attendance log, your weekly progress notes. You want to journal your experience, what you learned, how you applied it, and how your visits went. That is so key. Let me repeat it. Journal your experiences, what you learned in each course or counseling session, how you apply it to your life and to your children, and make sure all of your visits go well. You want to communicate respectfully with your attorney and your caseworker. My grandmother who raised me used to tell me you get more bees with honey. Keep that in mind while you're going through this process. I'm not telling you to kiss anybody's ass, but I'm telling you to become persuasive and be your own best supporter. I recently had a young man who I represented. He was about 28, 29, and he and I had this conversation early on in the case. He didn't like the conversation, but he came to learn that in order for him to win or have the best chances of winning, he took my advice, and today he's thanking me for it. Spoken or undocumented progress doesn't exist in the court or the judge's eyes. Spoken or undocumented progress doesn't exist in the judge's eyes. Make sure that everything is documented. Part 4, monthly reunification milestones. Each month, you should request updated letters of progress from your parenting instructors, from your therapist, from your visitation monitor, from your drug and rehab counselor, from your anger management or domestic violence counselor. And you need to send an email summary of your progress to your lawyer and to your social worker. You want to submit clean drug test results or any updated documentation. Ask your court-appointed attorney to file a brief update with the court if possible. And hopefully you can do that every month. Hopefully you might even be able to write that update for the judge, for your attorney to sign and file for you. Here's a pro tip. Begin assembling your package of reunification services before the 6-month or 12-month or 18-month hearing. Don't wait till the last minute. Part 5, preparing reunification evidence packages. You want to create a binder or a digital folder with the following: copies of all your certificates, letters from your providers, visitation logs and summaries, proof of housing, employment, childcare, calendar of completed tasks and classes and counseling sessions, and a cover letter from you summarizing your efforts. Remember, going to the course is only half the battle. I see so many reports from social workers who don't want to give you your children back because they'll say, oh, Vince went to all the courses, all the counseling, but he didn't learn anything. Now, how can they say that? They weren't even there. How can they say that? They barely talked to me to find out what I learned. But it's something social workers often put in reports. And all too often, judges believe the reports of the social workers. They are supposed to, by law, consider what the social worker writes, right? And the judges assume the social workers are telling the truth in their reports. I can tell you from doing this, almost 40 years, that's not accurate. Sometimes social workers have their own agenda. So you have to protect yourself. You want to make those summaries. I tell a lot of people, do your summaries daily, not just weekly, so that you can tell the judge what you learned, how you implemented it in your life and with your children. And then the social worker can't generally say you didn't learn anything because for the entire 6-month period, you've been writing this sort of diary that you can now use in court to prove that the social worker is not being accurate. Part 6, presenting progress in court. Let your attorney do most of the talking. This is extremely important. Yesterday, I did a case where in the past, my client had a habit of speaking out, addressing the judge during the court. At least with me, please don't do that. If you have an attorney that knows what they're doing, they will keep, they got your back and they will cover what needs to be done or said to the court. So let your attorney do most of the talking, but have your declarations ready from your therapist, your visitation supervisor, your parenting instructor, your domestic violence counselor, your anger management counselor, your substance abuse counselor. At the court, I want you to dress professionally and bring printed copies of your reunification completion packet. Focus on key phrases like substantial compliance, stability in housing and employment, therapeutic insight and behavioral change. Part 7, fixing mistakes and delays. If you've missed visits or services, take responsibility without defensiveness. Document why, hospitalizations, transportation issues, etc. Show how you have tried to fix it. Remember, the court is not interested in perfection. They're interested in progress. If you started your reunification services late, show an accelerated effort. For example, go twice per week to your drug counseling. Go twice a week to your domestic violence counseling. Double up and triple up on classes if you're way behind. You can always ask for an additional 30-day review before you reach court. So that's something you might want to ask your attorney. And strategically, in a lot of counties, in a lot of courtrooms, on the 6-month or 12-month or 18-month date, if you don't agree, you're going to be picking a trial date. And that'll give you an extra 30 days or so. Now, that doesn't happen in all cases. So make sure that you talk to your attorney on how that judge works. I'll give you an example. I did a case in Northern California recently, and this is done even in LA in some courtrooms. You get the report for the 6, 12, or 18-month hearing maybe 10 days beforehand. And when you show up on the 6-month hearing or the 12-month or 18-month hearing, the judge is expecting you to go to trial if you're a witness, if you don't agree with the social worker's recommendation. So that means you got to have your witnesses there, right? Your exhibits there. You know, there is something that you have to consider. This happened yesterday, and I saw this happen. I see it happen all the time. Sometimes attorneys show up with exhibits, and they expect all the other attorneys to agree that those exhibits will be admitted into evidence. It didn't happen yesterday for this one attorney. The social worker, the attorney introduced exhibits, and the social worker and the minor's attorney and I all objected to the exhibits because they were hearsay. They were without foundation. Nobody knows if those exhibits were true. So make sure you talk to your attorney that your attorney has figured out how to get those exhibits into evidence over other attorneys' objections. Were you going to say something, Ms. G? You unmuted yourself.
Yeah. What did you, that last part you said,
Mm-hmm.
Submitted into evidence, but didn't that attorney submit it into evidence?
Right, but there is an objection the county council made, and the minors council, and me, because I wasn't in agreement with those exhibits from another parent coming into evidence. Let's say that your attorney submits a letter from your drug rehabilitation program,
Mm-hmm.
and the person that wrote that letter is not present. Unless you have an agreement between all attorneys, which is sometimes rare, that document is not admitted into evidence for its full force and effect. The reason is that document is hearsay. The reason is that document is without foundation. Okay? So you don't want to get caught in that situation where your attorney submits letters at the last minute without all the attorneys agreeing that the letter will come into evidence.
So the attorneys, all of them have to agree.
Correct. Now, in this particular case, the attorney didn't get the agreement of the county council. And the county council told me before the case even started, hey, I'm going to object to that attorney's exhibits. He just gave them to me. I don't have any way of checking or verifying anything. So it's hearsay. All right? So if you and your attorney are going to try to admit evidence, pieces of paper, documents, you want to make sure that your attorney has in writing via email, preferably, that all attorneys agree that those exhibits can come into evidence. In this particular case, it seemed like the attorney had gotten the documents very late in the game. So he couldn't ask anyone to agree that the documents would come into evidence. And for the documents to come in evidence and have a full force and effect, he would have had to have the custodian of records subpoenaed to come to court, or the person who actually wrote the letter and signed the letter come to court and say, yeah, judge, I wrote that letter for the mother in this case. And yeah, she's doing great in her drug rehabilitation program. But
Okay.
when you don't have the agreement or the witness there who wrote the letter or the custodian of record, that piece of paper doesn't come in and it isn't really considered by the judge.
But I have a question. Isn't that attorney? I mean, I guess is he a family law attorney or just a CPS defense attorney? Because if he or she is a CPS defense attorney, wouldn't they know what they're doing? I mean, that really blows my mind. It blows my mind sometimes when people tell me my attorney is a CPS defense attorney, but wouldn't he or she know what they're doing?
You know, an attorney asked me yesterday about that regarding this case. And I said, look, I don't know. I can't comment on that person. I don't know that person. You know,
Right, but in general, there's a lot of people who tell me, parents who tell me, Georgette, I hired a CPS defense attorney, but he did not do the job. But I
well, you
told
know,
myself, how? How are you a CPS defense attorney?
well, you're a CPS defense attorney because you say you are. I
Hmm.
mean, you know, I could say, I'm a open heart surgery doctor. You
But
don't
you have
really know. You won't really know until I'm performing the operation and the patient dies on the table, right? I can say I'm anything. Any person can say they're anything. And then, there's all kinds of different levels of the type of CPS attorneys,
Mhm.
right? You just assume that your CPS attorney is Johnny Cochran reincarnated. That's not true. You know, eh, like everything else in life, there's different stratuses. So you could be a CPS attorney that's a 1 on a scale of 1 to 10. Or you could be a CPS attorney that's a 9.9 out of 10. Or you could be a 5 out of 10. It
Yeah,
just depends on your experience, your education, you know, where you are on that scale. If I tell you I'm a CPS attorney, you just assume I'm a 9.9 out of 10. But that's a
yeah,
wrong assumption. That's a wrong assumption. And unfortunately, well, maybe not you, but most people don't know what to ask and how to determine if a person is really a 9.9 out of 10 CPS attorney. You wouldn't know what to ask. And if you ask, I'd probably tell you something that's, half true, right? So
yeah.
ask me if I'm a CPS attorney.
Are you a
George,
CPS attorney?
absolutely I'm a CPS attorney. I've been doing this many years.
Many years.
Yeah. So what does that actually tell you?
No.
Nothing.
Mm.
It actually tells you nothing. So you got to do a little bit of your own due diligence, right?
I have people that say that parents will tell me that that attorney sounds aggressive. He's gonna fight for me and get me justice. I said it's not about being aggressive. It's knowing the law and knowing how to stay calm under pressure. Because what CPS does, they provoke you in the courtroom. They provoke other attorneys, private attorneys,
Yeah.
and
Well, being aggressive,
it doesn't do the job though. I mean, I'm
well,
just saying.
it's a good quality, right, to be aggressive, but you also have to know evidence. You have to know the law, the case law, the rules, and have experience. I mean, I've been in cases where attorneys have made arguments that are clearly not even the law.
True. I've
And
heard
when a
that.
judge and when a judge tells you something like, "What are you talking about?"
Hmm.
You know that your attorney is not the legal scholar in CPS law that you thought he or she was.
Correct. Correct.
So, you know, in my view, and this may be different for other people, if you make an argument to a judge that's clearly not the law, okay, you lose credibility with that judge, in my mind. And then when it comes to making decisions on close calls in the case, if you've lost credibility with the judge, that's hard to get back, right? And it's going to harm your client.
Right. I agree with you. But again, parents, they don't know. They think what I meant by saying aggressive, they want somebody that will shout into court. Like, you know how the parents are so angry they want to let it out? They want
Mhm.
their attorney to shout, "Hey, Your Honor, you're, you know, wrong. You're a piece of shit, Honor. You're a judge." And they wanted their attorney to be so aggressive, and they
Right.
think that attorney is going to do that job because he or she will say, "I can get your children back, blah 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 blah. I'm going to fight for you. We're going to go to Disneyland together when you get your kids back." Stuff like
you know,
that.
there's only one attorney that I've met who pulls that strategy off, the aggressive strategy
Hmm.
off. And he's been doing this. I've been doing this almost 40 years. He's been doing it almost 30 years, CPS cases.
Are you serious?
I only know one person that uses that strategy and is effective a lot of the times. A lot of times it boomerangs on him in that aggressive strategy, because, judges sometimes react, they're looking for respect from the attorney, right? And if the attorney gets too aggressive, it backfires on the attorney and on the client. But in a weird way, the client's kind of satisfied because they got their punch in on the judge or whatever, but the judge is making the decision, right?
Right.
The judge is the boss in the courtroom, not you. And knowing that rule, you have to tailor your strategy on how to get along with that judge, right? I can tell
But
you on the rare occasions that I have gotten overly aggressive with a judge in court, it doesn't turn out well. It
no, it
doesn't turn
does.
out. Yeah. So, you probably want to refine your aggressive strategy. And, as my grandmother said, which I didn't understand until I was 50 years old, you get more bees with honey. And that
Right.
includes with judges,
Right.
right?
Right. But
So,
I've seen you stay calm under pressure in ways that I wouldn't be able to. I've
well,
seen
that's
that
part
they go,
of.
but then, wait, hold on, let me finish. And
Mhm.
then the judge actually listens to you. But because I've seen you also throw codes, I've seen you do a lot of stuff calmly in a way where you get people's attention. When I see the other attorney being all loud and stupid, I don't want to listen to them. Get it? Whether they're good or not, I don't. Being on the third party, sitting behind you, I don't want to listen to that attorney. I want to listen to what you have to say. Not that I'm biased, but it just when you speak calmly to the judge and you state facts calmly without all this aggression, I think it shows the character of you knowing what you're talking about.
I learned that. I
Is that
wasn't
right
born that
or
way.
am I wrong?
No,
Okay.
no, I think you're absolutely right. And it's something that I learned over the years in going through trainings like the Jerry Spence Trial Lawyers College.
Yeah, I
I
went to
can
fail
tell
that.
you that at the Trial Lawyers College, if you came off very aggressive with the judge, you might get your hand slapped
Hmm.
because that's not, a good strategy in most cases. And a lot of people don't understand that. They want you to be aggressive and, yell at the judge.
Because they're
Well,
angry. They're angry. That's why.
and you got to have that conversation beforehand. Look, I tell clients all the time, I'm trying to win. I'm not
Mhm.
trying to make you right. You
Yeah.
hired me to get your children back, right?
Mm-hmm. Mm-hmm.
And with all my experience that I have, this is the best way. Now, if you don't want to listen to that, it's okay. I used to get upset, 25, 30 years ago, but I don't anymore. I'm going to tell you what I think you should do, right? I'm going to do it the way I think is most effective. And that will give us, in my mind, the biggest probability to win. Now, whether you get your personal satisfaction and your chunk of meat out of the social worker, we could leave that for the civil rights lawsuit. I had a conversation with someone today. I've been speaking to them on and off, maybe for a year, right? She called me this morning, maybe 5 o'clock a.m. I'm not really awake by then, but she called me. I took the call and she says, I'm very, very upset. And I said, what? She said, well, I decided not to hire you several months back. I paid this attorney all this money.
I know who she
And,
is.
and now I'm not getting the results and he's abandoning me. And now I want to hire you. Well, here's the problem. The case has moved on. The attorney that you did hire has screwed it up even more. And now you want me to come fix everything. It's not going to cost the same thing as I told you 6 months ago.
Yeah.
People think that I can just come in and pick up a case and fix it without doing more work. So the longer you take to hire me, the more work I'm going to have to do to fix the case. So in this particular case, it's up in Northern California. She hired an attorney who I know of. I don't know him, but he's supposed to be a very experienced CPS attorney. And for whatever reason, it didn't work out. And now she's come back to me and said, hey, I want to hire you today. It's July 2nd, people don't have the time they think they have. When I first talked to her, she was at her 6-month review. She is now getting ready to go into a trial for her 12-month review. And if she loses the trial, they're going to set a selection and implementation hearing to terminate her rights in 120 days. That's a different case than hiring me at 6 months.
Right.
At the 6-month date, on a scale of 1 to 10, 10 being the hardest, you probably had a 5. There's a lot of things that I could do. At the 12-month date, on the degree of difficulty, it's probably an 8 or a 9.
Right.
So it's a harder case to win. And there's more things I have to fix.
Right.
Well, why can't you just pick it up at the same price and amount of work when it was the 6-month hearing? Because things change in these CPS cases every day, every week.
And I just want to emphasize on that. I didn't know how complicated it is until I started, when I transitioned my careers from banking, finance into law, right? And I realized the amount of work an attorney has to put in when it comes to any case, actually, but especially CPS. And I've gotten so many calls in the last couple of weeks where the parents think their case is easy. Oh, it's an easy win. It's an easy win. You don't know crap about what an easy
I
win
don't think they
is.
really believe that. I
I
really
swear,
think that
that's
they
what they
say it. They say
Yeah,
it because they want you to
crazy.
take the case and they want you
Mhm.
to charge them a cheap price.
No, it's not going to work. Not with me.
I've had people though say, Mr. Davis, come in and snap your fingers, you'll get my kids back.
Yeah, like
No,
that. They
that's
think
not
you're
going
a
to happen.
musician. Yeah, I
Yeah,
know.
it's not going to happen. You got
It's
yourself in this situation over weeks and months. It's going
not
to take me at least weeks and months to get the kids back.
right. And they think that you're going to throw magic out there. I said, you're not a musician. I mean, yes, you win cases when the clients listen, when they actually listen to you, when you give them advice and they actually take your advice. I've seen clients lose cases because of their own stupidity. I've seen clients lose cases because they listen to, advocates online. And there's so many things that a parent can do to lose their case. And to me, is if you can't hire Davis from the beginning, don't wait 18 months and then expect Davis to get you results within a day. Like this other parent I had Davis talk to on the phone, she said, "Can you give me my kids back next week?" I mean, Davis doesn't know anything about the case. And mind you, not she doesn't want to pay him what she paid her other attorney. She paid him 15,000, and she wants to pay Davis 1,500. That's all she has left. Is 12. I mean 1,500. That's all she has left. Well, she had paid the other attorney 15,000. So she wants Davis to do everything, fix everything that the other attorney did for 15,000 for only 1,500. I mean, I don't know if you guys understand that, but if you don't get the proper attorney from the beginning, your case cannot be salvaged. Am I right? I mean, I don't know. I don't know.
It makes it much more difficult to win the case.
Not
There's degrees of difficulty. If you hire me at the beginning, there's so much that I can do, and as long as your case goes more and more and more and more, the harder it gets to get the children back.
right. Because when you hire him in the beginning, you could have a good lawsuit. To me, in my head, he's already building that, right? So if he doesn't know anything about your case and you think you have a good lawsuit when he never handled your case, it's impossible, because I know you don't have a good lawsuit. You know why? Because your previous court-appointed attorneys or whoever you hired screwed it up already to have a good lawsuit. Does that make sense, Davis? Or
Makes sense. Hey,
yeah.
listen,
So
we're way past the end of the show. I want to wrap this up. I want to tell you, don't forget, if you want that free consultation, call the number on the screen, 888-888-6582. Ask to speak to Georgette or Miss G. She will set up the free consultation. If you speak to someone else in my office and you want a consultation, they're going to charge you. All right?
Yep.
So only go through Georgette if you want the free consultation. And I'm only doing that for people she speaks to because she's been asking me to do it.
I've been
So,
only asking you for the last 10 years, but that's okay.
so she'll set it up for you. Also, I don't know if I told you this, Georgette, but the marketing department is offering a 25% discount on legal fees for the 4th of July.
Oh, wow. I didn't know that. When did that start? Today?
I just saw the email this morning.
Oh, okay.
So, but it's only for the 4th of July. And I think it ends either today at midnight or tomorrow at midnight. I didn't really read it. So if you talk to people today, there's the 4th of July discount we're offering.
And I'm also, oh, wait, hold on. I'm also dedicating the 4th of July holiday to the public. So if you guys want to call, you can call me directly or you can email me. And my number is right here underneath my chin. I think next to my face, there's a number right there. And also, I'm going to have you guys email me as well, too. Okay. So I'm going to put my email here. And then you guys can also email me your name, phone number, a little short story about your case, and I'll be calling you. So that way you guys can also get help. Hold on. Here we go. VincentWDavis.com. Here we go. So here's my email. So make sure you keep that in mind. You guys can reach me on 4th of July. Okay. I am going to be servicing everyone.
Okay, folks. Ms. G, thank you for joining me this morning, and we'll see everyone on our next office hours. Everyone have a good day. Bye-bye.
You too. Bye-bye.